Thank you. Talking about local control here, we're talking about local politics with this Freedom of Information Act, this open meeting law. The next time there's going to be a controversial bill, there's going to be a bathroom bill in Conway, and it may be a group of liberals who are on that school board and not a group of conservatives who want that bathroom bill. There's going to be a sexual assault in Huntsville, Arkansas, in the boys' bathroom. There's going to be a multi-million-dollar economic development project. The choices are clear. We have two choices here. We have this bill, Senate Bill 382, which says two people cannot meet and discuss what's happening in the boys' bathrooms and the decisions that are going to be made, or the multi-million-dollar economic development project, or the bathroom bill in Conway, Arkansas on a local level. Those discussions, according to 382, those discussions, those deliberations, and those decisions, they have to be before us, the people. This is the people's law. They can discuss it as long as they want to. And you know what? They can ask those tough questions that they want to discuss in the closets, in the back of the McDonald's. They can ask those tough questions and make those tough comments before us, the people, because we are entitled to see the sausage making. As the Supreme Court says, we not only need to see the decision, we need to hear the conversations and why they're making that decision. Or we have the choice, which we've heard referenced here, which is House Bill 1610, which will allow less than a quorum. So in Fort Smith, where I come from, 6 out of the 13 can meet at the back of the McDonald's or on a secret email chain or a secret text chain, and they can discuss our business, they can deliberate our business, and they can decide our business. And then once the 6 get finished, 2 of those 6 will meet with 4 or 5 of the others, and they'll make that secret decision. And then they have the decision. It's a done deal. The multi-million-dollar economic, and we, the people, never see anything. And I'll leave you with this point. Here's the gold standard and here's the test. Or strike out section 2519-102 and let's say it's a farce in Arkansas. 2519-102 says, and I'm going to repeat it one more time, it's vital in a democratic society that public business be performed in an open and public manner. Does Representative Bentley's bill, does it meet that gold standard? Does your bill, Senator Payton, meet that standard? I would suggest not. The only bright line test here is you do not allow 2 members of the governing body to have conversations outside of we the people. It's the only way it works. Otherwise, you're going to have A, B, and C meeting in the back of the McDonald's. Then C is going to go to D, E, and F, and the decision's going to be made, and the people aren't going to be happy. And that is not public. That is not a public decision. That is not open government. So we might as well drive a heart through 2519-106, the open meeting law. Just strike out the whole thing and let's just do what we're going to do. Let's just allow local governing bodies to discuss our public business, make their decisions, and then come in and take their vote without any discussion. But I don't think that's what we want in a democratic society, because FOIA, and I'll close with this, FOIA is not a Democrat issue or a Republican issue. FOIA is not a liberal issue or a conservative issue. FOIA is a freedom issue. It's a liberty issue. And if we cannot see what our governing bodies are doing, then bad decisions are made and corruption happens. Period. Corruption will happen, make no mistake about it, if we allow our governing bodies to make decisions in smoke-filled room down here at Doe's Eat Place. It will happen. And we've seen it on the statewide level over the last several years, the massive corruption. And maybe it's because we're allowing all these discussions to occur. And it does have to occur. It's a different body. The legislature meets 2 months. It's a huge body. And you have to have some of those discussions. Winthrop Rockefeller appreciated that. And he got this passed when there were all Democrats. And not only that, public bodies are meeting almost every day. They're meeting weekly. They're small bodies. But if we allow them to meet in secret email chains, or in what Fort Smith called in the Wade case, which I tried and took all the way to Supreme Court, and the Wade case made a decision that unless a decision's made, you can have 3/7 of the governing body on secret email chains, 3 of them making a decision in a secret email chain to abolish our Civil Service Commission. Is that the way we want government to operate?
Sir, you address this body.
Thank you. Is that the way we want our government to operate? Where in the Wade versus the City of Fort Smith case, you can have a private email chain by our governing body. 3 of them have discussions and make a decision. The other 4 are listening to the discussion, and then we go in and have the vote where the public never knows that's going on. And I suggest to you that's what will happen if we don't have a bright line rule where all discussions, every single discussion occurs in a public meeting. Because the shoe will be on the other conservatives, the shoe will be on the other foot at some time, and we'll regret this decision. Because what I want to conserve is the Freedom of Information Act. And what I'm concerned about is we will have no open meetings provision if this bright line test 382 is not passed, and instead we pass House Bill 1610. Thank you for listening.
You want to close, Bill?
Thank you, Mr. Chair. And committee, I appreciate your great patience today in hearing these bills and hearing all the testimony, and I mean that sincerely as we're getting toward the end of the session. Isn't this a great country that people can just come and testify, and that we just common people can be senators? You know, if I'd have come here 20 years ago, I would have thought, well, you know, y'all are senators, but now you realize that it's really the people. And so people look at each one of you and the vote you make, and they think it's you, but you represent 90,000 people. And I'm glad there's 2 bills, because there's Representative Professor Steinbach said it best when he said this is seeking a balance. And obviously this law would have never been passed in the beginning, except we had the problem that one of the witnesses talked about of a school board meeting where, and then the member of the press brought a city council meeting where obviously the decisions had already been made. You know, as a former quorum court member, people ought to at least have enough sense to act like they're having a discussion, because that's irritating to people. They want their government to act the way government ought to act. And so I'm here today representing the people that want it to be open. I've been a quorum court member, and I understand the practicalities of not being able to visit with one other person. But there was a reason why these laws need to be enacted in the first place, because there was way too much of this, everybody deciding and then coming and voting. And as we've heard today, it's still going on. And so you have this bill before you, and I'd appreciate a good vote.
Thank you, Senator. Is there what's the will of the committee?